Welcome to BIB Daily, the podcast from the newsroom of Business in Vancouver. I'm Kirk LaPointe, the publisher and editor-in-chief. This week, our podcast is examining the changing nature of work, its dynamics and challenges in the pandemic era, and how employers and employees are adapting to what we now know as the new normal. Our series is brought to you by the worker compensation organization WorkSafe BC, by the law firm Harris & Company, and by the professional services firm Deloitte. We're still sorting through the legal questions about the workplace in the pandemic, mainly because we haven't had to ask ourselves about them in such scope at one time. But there are very clear requirements under the law and many emerging questions about where that law might apply. And to sort them through, we brought in an expert. Lindsie Thomson is the managing partner of the Harris & Company law firm here in Vancouver. Good to have you with us.
Thank you. Pleasure to be here.
Can we try to identify, at least at first here, what are the real legal obligations of the employer now that we know that remote work is here to stay?
Yeah, I mean, in the past, we would have had the odd question here or there on remote work from employers who wanted to do something for their employees in terms of, a benefit or improving culture. And typically our advice has been, you have the same legal obligations for safety, privacy, hours of work as you do when they're working in the office, but very little ability to manage those issues remotely. So, some would take it on regardless, and others would just abandon the idea. And then, like you said, March 2020 hit. Everybody has to immediately work remotely in order for the business to survive. Concerns about technical legal requirements end up on the back burner, and frankly, survival becomes the primary goal. Connectivity.
Yeah, I remember far enough back in that period, don't you? I mean, where actually it was like, I'm not sure this is legal, but we better do something here.
Exactly. Yeah.
Have we swung back though now to where we're getting our feet again around the legal requirements?
For sure. I think that initially, as you say, everybody sort of relaxed their expectations in terms of legal requirements. We're now nearly 4 months into this. Reality is setting in. It's going to be a long-term, effect. So now these expectations are coming back to the forefront. And we have to turn our mind to, look, what is the regulatory environment? How do we reduce risk on that front? And, one of the key things here to remember is that the legal regime for the workplace was not built for the digital age. It was built for the industrial age. It was built for a time when you had people in front of you, you were supervising them in person. So we have to kind of reverse engineer some of our processes, right, to be compliant.
Does that require a pretty broad rethinking?
It does in some senses, yes. I think it's going to require some creativity. I think it's going to require us to rethink how and why we did things in the past and how we can meet the same objective without necessarily doing it the same way. So, initially you saw employers just Band-Aid solutions all over everything. We'll just send you home your chair from the office and a monitor and off you go. You're sitting at your kitchen table. And yeah, that's not good enough long term. We do have to rethink. And so, employers need to ask themselves, where are they on this spectrum? Are they in the Band-Aid zone? Or have they moved to a place where they're bulletproof going forward and these are not risks for them anymore? So, that's really what we're seeing. People, they need to ask themselves, where are they in the spectrum?
Well, let's leave the Band-Aid people alone for the time being. Let's try to figure out how you get bulletproof, to your point. So what are the actual legal requirements in general that employers have toward their employees?
Sure. So, there's two that are key. And this is obviously assuming that you are supporting remote work. You don't have to allow someone to do remote work, and we can talk about that later. But assuming you are supporting remote work, then the answer is, pretty much everything you're required to do for them in the workplace, you're required to do for them in their remote work environment. Two kind of key ones that are obvious ones is the safe work environment. This is one of the biggest considerations and one of the sort of biggest areas of concern for employers. Employees might be working alone. They might not have a safe setup. They might not have an ergonomic setup. Lots of people working at their kitchen counter. So these aren't long-term solutions. You do have to take those regulatory requirements for ergonomics, for reporting hazards, having a safe workplace, and figure out how to make that work and manage that in an employee's home or in a remote setting. So that's kind of one major topic.
Well, I'm not going to let you get away to the second major topic before we get to that one, because that sounds to me like an employer has a duty to ensure that you have the right chair, you have the right desk, you have the computer screen at the right level. And again, these are white collar issues, obviously.
Yeah.
Is that a legal requirement, or is there some fuzzy area in there?
Yeah. So I'll be watching with interest what the WorkSafe person says in terms of their answer to this, but certainly the information that they're posting on working from home does call out that employers do need to ensure there's ergonomics taken into account when you're setting up at home. So, for example, I think it's a key question here. Are you the one as the employer asking them to work from home, or is this a voluntary measure that they've asked to work from home? Either way, you have an ergonomic issue. But if the employee is the one pushing it, then the cost of that it's a question mark whether the employer really has to, buy a new chair, buy a desk, heck, give them more money to pay for a bigger apartment so that they have a den or office, right?
Right, because I think this is a fair territory to explore now. I think a lot of employers are beginning to wonder just what will be my obligations if really I can't bring everybody back to an office space. I don't have the dimensions correct for that. I'm going to need to have some people work from home in order to facilitate this. So now what do I have to do?
Yeah, exactly. So, they're going to need to think about what's the setup that they have at the office? How many people can they rotate through the office? Is there a middle ground they can find for people working from home temporarily, such that they're not having to both outfit an office and outfit a remote office? Because that's not going to be viable either, right? So, there's going to have to be a balance found here. But for sure, we're going to have to pay more attention to ergonomics than we've been doing in the past 3 or 4 months, because it's basically been getting zero attention so far.
Okay, so then, and again, I know you're going to get back to another major area here in a sec. It sounds as if the employer-employee relationship begins to get a little more casual the longer that you're in this remote work situation. So again, what is an employer permitted to do in terms of managing an employee when you're off-site?
So like not anything to do with the ergonomics, but just in terms of how we manage their workflow and that kind of thing. Is that what you're wondering?
Yeah.
Yeah. So, the fundamentals of the relationship are that you're still the employer. You're still entitled to expect productivity from your employees, and you're going to have to figure out how to manage employees remotely. No longer is it good enough for us just to look at them and say, well, they're at work, they must be working. Management of employees is going to have to be more substantive. We're going to actually have to find solutions for figuring out, are our employees productive? And backing up for a second, if you don't have a baseline of what productivity you would have expected while they were in the office, then you're going to have to put some work into figuring out what is an appropriate baseline of productivity in order to measure whether they're there or not. But we're going to have to be creative.
And creative, but also, can you really expect as an employer that you're going to get the same level of output, of productivity, of efficiency from someone who isn't in an office terrain?
Yeah, I think that's probably an individual question, an individualized question.
Mhm.
Lots of people work really well in a quiet space, and if they have a really great setup at home where they can just focus and get things done, they might actually be more productive than when they're at the office and people are visiting or chatting amongst themselves or distracted in other ways. So I don't think we can say on the whole that we're going to have less productivity across the board if people are working remotely. I think it really does. It is going to be dependent on personality and the individual, but also your ability to adapt as a manager and to really find new ways of continuing to get the person to be productive.
But the law doesn't prescribe any kind of one-to-one type of approach with an office as opposed to a remote situation. The employer isn't particularly entitled to expect exactly the same thing.
No, I mean, the law basically doesn't get into the weeds in terms of, productivity benchmarking or anything like that. As an employer, you're entitled to a productive employee. And if they're not productive, then you would take steps to manage their performance. So, I guess the question might come up around someone who's less productive. And let's say they get put on a performance plan. They might say, well, that's not fair. I'm working from home. But that doesn't really hold water for me because unless there's a real reason why they can't be productive at home, I'm not sure why that wouldn't be a fair thing to talk to them about.
Again, is there anything in law or in any kind of practice that helps us understand what we're going to do with those, for instance, who are still looking after an aging parent or children while trying to juggle the demands of an office, right?
Yeah, I mean, that's a big question. So you see requests for what's called an accommodation. People who want to work from home because they don't have childcare or because they have an ailing parent and they want to be able to work from home in order to do both of those things, essentially. And that raises a really interesting question. I mean, as the employer, you need to think about whether that is going to fit with your model. So if there's a real question mark due to the age of the children or the type of work that the employee has to do, if it's quiet work, focused work, or phone work that has to happen, and their children are going to be jumping in all the time, it's a valid question to say, I'm not sure whether this is going to work for you to work from home. So those types of discussions are going to have to happen. And, if the person cannot do productive work at home, you may, and because of COVID, they don't have childcare or something like that, then, it may be that they have to look at a COVID leave or some kind of leave of absence instead, temporarily, of course. But yeah, so I mean, there are certainly challenges there.
And an employer, does an employer have the right to order someone back in?
So in terms of coming back to the office?
Yeah.
Yeah. So, I mean, you do have the right to say where the work will be done. And so, as the employer, you're entitled to set up shop in Vancouver or Burnaby or wherever you like. And then you hire people, they're supposed to come to your workplace, right? So that's the default. People who are concerned about coming to the office because they don't want to take transit or they're uncomfortable because there will be a number of people in the office and they're not sure about whether any of those people have been exposed. That type of discomfort is not something that you have a legal obligation to accommodate or to say, yeah, okay, you can work from home. We don't have a choice. As an employer, that would require a soft touch in terms of managing those issues, but there's no legal obligation to allow that person to work from home just because they're uncomfortable. If they have an illness and it makes them susceptible to significant complications due to COVID, then now we're into a situation where you may have to accommodate them with remote work if there's remote work available. And if it's if their doctor looks at your safe work plan and says, yeah, even though you've got plexiglass everywhere in between your workstations, and even though you only have one person in the lunchroom at a time, it's still too risky for them, then you'll probably have to have them stay at home.
Because it is possible, isn't it, that a lot of people who have been coming into an office setting will have some physical conditions now that really are over that line around COVID, and where their pre-existing conditions complicate things and provide a greater risk to them. And then there is a duty to accommodate in that.
Yeah, that's the conversation and the thought process you'd be having. So you talk to the person about, what is the condition, and you don't need the diagnosis, but you'd be saying to them, get your doctor to look at our safe work plan, see how we've rearranged the office, and make a determination and give an opinion as to whether it's still necessary for you to stay at home in order to stay safe. What we're seeing is that, now with restrictions easing in the retail environment, in public spaces, people are a little less jittery about coming into the office, even if they have some medical condition. But certainly in April and May, and potentially in the fall, if we see a resurgence and, bad weather in the flu season and all that, we might see that really become more prevalent.
Okay, I'm going to tap your power of recall, because I interrupted you about 10 minutes ago where you were looking at a major area, and I interrupted you, and we went down a rabbit hole together.
Okay.
There is, though, more major material here that we have to take into consideration.
Yeah, I mean, the second one that I thought was kind of a major topic is, and along this theme of the regulatory framework really being built for the industrial age, not the digital age, is this idea that under the Employment Standards Act, you have an obligation to keep payroll records with daily hours worked on each day, regardless of whether a person's paid by the hour or a salary. So
how are you going to do that now?
Yeah, exactly. Right. So, well, you could take a couple different approaches. One approach is to basically have the person, check in with you when they start, tell you when they're taking breaks, and you are both recording all of these things, and that's your record. Now you're taking them at their word that they're actually working in those in-between times, right? But lots of people are giving flexibility during the workday, and they're saying, look, I don't really care when you get your work done. If it's at 9 p.m. because you had to take your kids somewhere during the day, then that's fine too. And that's going to be more challenging, I think, to verify and to check on and everything like that. So it is going to be tricky.
It's certainly tricky, because I mean, a lot of people would use their commutes, for instance, to also take care of an errand on the way into a place or on the way home, right? So, well, okay, you're not doing that commute anymore. So you're presumably having to figure out when to do an errand.
Yeah.
And maybe the best time to do it is at 10 in the morning, or, like early afternoon when the stores aren't as full, kind of thing. What on earth are you going to be able to do from an employment standards standpoint in order to chronicle this and in a lot of ways to satisfy the regulator that you actually have a 40-hour a week or a 35-hour a week workforce going?
Yeah, I mean, so one of the things to keep in mind is, generally speaking, although the Employment Standards Branch can just come in and do a spot check on any employer, they typically wait until there's a complaint. So most of the time, employers get a little bit lax in this area because they don't tend to get these requests from the branch. But that doesn't mean that the obligation isn't there. And if there is a dispute, now they don't have the records, right? So the key is really to ensure that you're figuring out how you're going to keep a record of this and keep an accurate record as much as you can.
Yeah. In any place that I've worked, there have been one of two types of cultures. One is very strict, you're here between this hour and this hour, and you'll have your life to yourself once those hours are done. And then the other one is, which I think is much more common these days, which is, look, you got a dentist appointment, you got this thing to do, you got that thing to do during the day, whatever, I trust you to make up the hours. So, okay, so what I wonder about in this case here is, do employers have any right, as they're providing a little bit of this flexibility in people's lives to work remotely, to then expect that they're going to be available to them in the evening hours or on a weekend or, at an off hour, or like how does an employer get guided right now on this one?
Yeah, so I mean, the Employment Standards Act sets out hours of work provisions and regulations, and you're not supposed to, work overtime without paying extra if you're not a manager. There are certain breaks that are required. There's even, thought that there's even the concept of a split shift, right? Or being on call. So all of these things are there, but we're not really thinking about them in terms of the remote work environment, right? And they're really not that well suited to the remote work environment. So it may be that you need to take a look at your needs and the employee's needs and come to an arrangement of a flexible a schedule. You might need to apply for a variance to certain employment standards requirements. If you want to go that route, that's an option. There are some things that you can get a variance from. But all of those requirements are still quite rigid, even if you do get a variance, right? So you really do have to work with your employees, figure out something that works and not push the envelope. Because the moment you push the envelope and say, well, in order for the flexibility, I want you to now answer your email at 10 at night, you're going to start getting complaints, right? Yeah. So it's keeping it reasonable, I think, is the key to reducing the likelihood.
That sounds so common sense. Last area then, I mean, I think we almost started with this, which is how the Standards Act was really generated in an age where we weren't using the word pandemic at all. So here we are now, and we recognize that we may have a second wave coming, a third wave, who knows, and we'll certainly have future pandemics. Are we due now, do you think, from a legal standpoint, to do a pretty good overhaul about what we consider to be employment standards in this very changed and changeable age?
Yeah, I think that if you look at the way the Employment Standards Act is set up, it's got all these rules, and then there's a regulation, and most of the regulation, 14 pages or something of it, are devoted to exceptions. And these exceptions have been incrementally inserted into the regulation based on a particular sector or a particular type of employer, making a pitch to government as to why the rules don't really fit for their sector or this job or what have you. High tech is a perfect example of that. And, so we have this sort of general rules and then a whole ton of these exceptions. And that does beg the question, should we actually be rethinking the rules if we have so many exceptions to them now that it takes up 14 pages in the regulation? So yeah, I think it is something that is worth looking at. It's political, obviously, too. I mean, making changes to an employment standards legislation or any workplace legislation is delicate. Someone
wins and someone loses, right?
That's right. So it is, having that idea about it being about flexibility, but also building into that a means to protect employees from employers who are going to take advantage of that flexibility. I think that's the key, right?
Yeah, totally interesting times ahead. But I really thank you today for talking to us to at least straighten away where we are now and what we're going through. And it's such a great topic and on everyone's mind as we try to reopen businesses and try to get ourselves back to the economy that we remember only a matter of 4 or 5 months ago. Lindsie Thomson, thanks so much for joining us.
Thank you very much.
Lindsie Thomson is the managing partner of Harrison Company, a law firm here based in Vancouver. I'm Kirk LaPointe. Thank you a lot for watching BIB Today. We'll see you again.